Good morning, everyone, or good evening, depending on where you are. I'm Dr. Sarah Razai, Research Leader and International Projects Lead here at BICL, and it is my great pleasure to welcome you all to this workshop on intellectual property as a tool for innovation and economic growth. Today, we turn our attention to how IP can fuel international commerce, strengthen competitiveness, and support the development of national and regional brand identities. For the Caribbean and for small states, more broadly, actually, we include the Global South here as well. Intellectual property offers powerful opportunities from leveraging place name branding to highlight the unique cultural and geographic identity to using IP frameworks to increase the value creation across industries and better position um, small states in the global marketplace. I'm especially pleased to announce that this event takes place in the context of a newly signed memorandum of understanding between BICL and the University of the West Indies, which marks the beginning of a series of future collaborations. And today we're joined by an excellent team of experts for two panel sessions. The first is Dr. Natalie Cortesi. Sorry, Natalie, if I mispronounce that. She's a senior lecturer in law at the University of West Indies, Muna campus, and a qualified attorney at law. She has served as associate dean at the Faculty of Law, launched the region's first LLM in intellectual property and the cultural and creative industries with the WIPO support, and previously held senior posts in Jamaica's civil service, including Director of Copyright at GIPO. And she continues to serve on numerous national and regional IP boards and committees. We're also joined in by Professor Enrico Bonadio, who teaches law at City here at University of London. Enrico's research, excuse me, spans intellectual property and new forms of creativity and innovation. He's widely published, serves as deputy editor-in-chief of the European Journal of Risk Regulation, and sits on several international editorial boards. We're also joined in by Dr. Andrea Zappalagio. I'm so sorry, Andrea. Zappalagio. I'm so sorry. I just butchered your surname. So Andrea is Associate Professor of Intellectual Property Law at the University of Leeds. His expertise includes branding, sustainability, and unfair competition. And he has worked closely with the European Commission and the UN Food and Agriculture Organization. Virtually, we're also joined in by Ms. Keisha Fleming-Lake, who is a managing partner of her own firm in Anguilla and has more than 20 years of legal experience. She's admitted to practice in Anguilla and other Caribbean jurisdictions, as well as in Michigan, Florida, and Missouri in the United States. We're also joined in by Ms. Grace Lindo, who's an IP and data protection lawyer based in Kingston, Chevening Scholar with an LLM from the London School of Economics. She's been recognized by the World Trademark Review as a leading Caribbean trademark professional since 2014. And she's also a certified information privacy professional and a notary public. Last but not least, Mrs. Diane Daly McClure, who's will be also joining us virtually. She's a founding partner of Foga Daly, Jamaica's first specialist IP law firm. And with 3 decades of experience, she's advised the government of Jamaica, represented the country at WIPO and UNESCO, and chaired multiple IP boards and tribunals. She's also a lecturer, WIPO tutor, and a published author on IP law. So I'm very excited about today's event. So our program is structured around 2 sessions. So the first panel, which will be about global IP review, will review global IP, is going to be moderated by Natalie. The second panel, so this will be followed. This will come after a dedicated Q&A session and a coffee break, is going to be moderated by Professor Enrico Bonadio and will be about competitive identity. And I'd like to welcome Natalie to start the first panel. Thank you.
Thank you so much, Sarah. Thank you very much to all my panelists this morning for giving of your time to participate in this inaugural event. We're very excited to be in this wonderful, rainy London environment. We're in a beautiful room at the British Institute of International and Comparative Law, surrounded by lots of scenery in a very historic Russell Square at the Institute of Advanced Legal Studies. Welcome to those of you online. Thank you for joining in. So this morning, we wanted to set the tone of this workshop on innovation in small states by having, I would say, an introductory conversation about intellectual property broadly, the regulatory framework for intellectual property, and of course, management of IP assets. As we already know, I believe, intellectual property is very much the pillar that supports just about any commercial enterprise and the ability of business entities to leverage their goodwill and commodify whatever it is they have to offer by way of goods and services. And certainly intellectual property is a very important tool of innovation for small states in particular. And today we will consider these topics in the context of the Caribbean. So I would like to invite Enrico to give us his comments on the introduction to intellectual property.
Thanks so much, Natalie, for the introduction. I will give a general overview of IP protection in the context of small island economies, especially in the Caribbean. So I want to emphasize here that how intellectual property can serve as a transformative tool for economic development when strategically deployed within the appropriate regulatory frameworks and asset management systems. So we all know that small island developing states face challenges that distinguish them from larger economies in their approach to IP. And the Caribbean experience demonstrates that IP systems, IP regimes must be calibrated to address specific vulnerabilities. For example, limited human resources, narrow economic bases, high transaction costs, and geographical isolation because they are islands, right? Yet there are also some opportunities. Some characteristics also create opportunities for leveraging IP as a development tool, particularly in areas such as where cultural identity and geographic uniquenesses may give these states competitive advantages, right? For example, GIs, and we will talk about this in the following panel, the emergence of GIs, geographic indications in the Caribbean, epitomizes this dual nature. We will give later examples of GIs in the Caribbean that have been protected not only in the region. These GIs, these protections have shown how place-based IP can transform traditional products into premium global brands. So IP here is a tool to empower certain sectors of the economies in these states. So as far as realizing such potential, however, requires appropriate regulatory frameworks and strategic asset management approaches that many small islands struggle to implement effectively. So what about the regulatory framework challenges? The regulatory landscape for IP in small island states presents, again, obstacles and emerging solutions. Most Caribbean jurisdictions, for example, inherited colonial era industrial property laws dating to sometimes the late 19th century or the early 20th century, creating a fundamental mismatch between legal frameworks and contemporary IP needs. So this outdated foundation has kind of necessitated comprehensive legislative modernization of efforts, sometimes supported by international organizations such as WIPO and the regional bodies such as CARICO, right? In terms of progress, in the Caribbean approach to IP harmonization, I could mention, for example, the Caribbean TM class initiative involving Antigua and Barbuda, Belize, Haiti, San Lucia, Trinidad and Tobago, San Vincent and the Grenadines. This initiative shows a sort of commitment to adopting international standards through regional cooperation. It is basically an initiative of regional IP development launched by the CARIFORUM Directorate and the CARIFORUM Intellectual Property and Innovation Project, CAR IP, in November 21. It helps basically users for and verify the correct classification of terms for goods or services in accordance with the criteria established by the NIS agreement for the classification of goods for trademarks registration. So users can verify whether particular terms are accepted by any of the participating trademark offices and obtain translation of those terms. So this is an initiative which helps especially reduce administrative burden. However, the main target, which might still be far to reach, is the creation of a regional intellectual property office. As far as I understand, this has been debated for a long time in the region. But if you think these states are very small and it doesn't really make sense, I mean, to go through a trademark registration procedure in Jamaica, another trademark registration procedure in Trinidad, we need, and we all know, we need a regional office which is capable of centralizing the procedures in order to save costs for entrepreneurs. There are obstacles, of course, because this, as I said before, has been debated for so long and it's not in sight yet. It remains constrained by two critical factors. First, insufficient political will for governments. Governments are still jealous of their, let's say, IP independence, right? And also the complexity of harmonizing diverse national legislations. But I think even those who stress these difficulties must accept the fact that sooner or later a regional IP office should be, the target, because, look at what happens in Europe with the European Patent Office and how successful has been since the 70s. Then now we have the unitary patents, but at least that regional patent agreement, the European Patent Convention, has been successful, right? In promoting innovation, of course, with the shortcomings, but I think that should be the target for the Caribbean, creating, at least for the English-speaking Caribbean, a regional IP office. Then what about TRIPS? How can TRIPS help? The TRIPS agreement, how can the TRIPS agreement help small islands, states? Well, there are flexibilities, for example, in TRIPS agreement, which are designed for certain countries. First of all, least developed countries. There is just one LDC in the region, which is Haiti, right? So Haiti is not obliged to implement most provisions of the TRIPS agreement. But the others country in the Caribbean, they are not LDC, and therefore they must comply with the TRIPS agreement. But even within the TRIPS agreement, there are flexibilities that can be used by small islands to pursue a public interest. For example, access to medicines. We have seen how these flexibilities were important during the COVID emergency, with the possibility of granting compulsory licensing of patents, parallel imports enabled by an international exhaustion of intellectual property rights, which small islands can implement, exemption for pharmaceutical patents such as the Boller exemption, and so on and so forth. But what I have learned is that the Caribbean states have generally underused these flexibilities for some reasons, especially because of the limited awareness amongst policymakers in the region that such, and also because of region bilateral trade agreements which have been entered into with big trade blocs such as the US or the European Union, which tend to neutralize flexibilities, and also because of inadequate technical capacity for implementation. Here, I think the WIPO could do more in terms of technical assistance in the region. Then we have the Doha Declaration on TRIPS and Public Health, which provides particular relevance for small states in the Caribbean. So for the Caribbean states, strategic use of this flexibility in TRIPS within TRIPS could support domestic innovation while addressing, for example, public health needs. What about legislative modernization and capacity building? In the last decades, there have been some legislative developments across the Caribbean which demonstrate some varying approaches to IP modernization. We have GI's laws in several countries that have been adopted, in Trinidad and Tobago since the 90s, in Jamaica since 2004. There have been several registrations of GIs in several countries, Jamaica, Trinidad, British Guyana, and so on and so forth. And then there is also the European Union CARI Forum Intellectual Property Rights and Innovation Project, CARI IP2, which is a major initiative designed to modernize and harmonize IP frameworks across Caribbean states, promoting, with the target of promoting effective regulation innovation through international cooperation. So this initiative by CARI Forum helps or should help countries update and align their legislations in line with international standards. And this includes, for example, reviewing and updating national IP laws, drafting model laws, and explanatory notes tailored for the Caribbean context, especially for GIs, supporting the adoption of international IP treaties to foster regional and global integration. A key pillar of this initiative, CARI Forum, CARI IP2, is empowering businesses, especially small and medium-sized enterprises, which are kind of backbone of Caribbean economies, right? There are plenty of small and medium-sized enterprises, rather than big corporations. There are also big corporations, but I think the backbone of the economies in these islands is made by small and medium-sized enterprises. What about IP asset management strategies for small economies? Of course, effective IP asset management in small island states requires approaches adapted to, as I said, limited resources, narrow market bases, and dependency on external markets. The US, for example, is the most important jurisdiction for Caribbean small islands. So, for example, given the resource constraints, small island states in the Caribbean must strategically prioritize IP asset development in sectors where they possess comparative advantages. A sort of a David Ricardo-inspired solution, right? Each country should specialize in products, in goods where they have a competitive advantages. And when it comes to the Caribbean, we know the products that are most important. Rum and coffee and certain food. I mean, there are several ones. So GIs, and we will talk about GIs more in depth in the next panel. There are several registrations of rum-related GIs or other GIs in the characterized sector, which have the effect of transforming the traditional products in a global brand. And here on this table, we have some example of this. Then what about music? Music is another important product where Caribbean small islands have a competitive advantage. Jamaican music, not only Jamaican music, Trinidad and Tobago with the steel pan music and many other music from these islands. These are very important sector. And for example, the Association of Caribbean Copyright Societies has pioneered regional collective management approaches representing over 10,000 copyright holders across the Caribbean. And they use the blockchain technology for providing services such as licensing, distribution of royalties, and this blockchain-based licensing solution epitomizes how small economies can leverage technology, new technologies like blockchain and smart contracts to overcome traditional barriers in IP. And the integration of blockchain technology in IP management presents opportunities for small island states. Smart contracts, for example, they can automate licensing process, track music usage. For example, on Spotify, on iTunes, there are millions of users worldwide who download or who listen to Caribbean music, and by using blockchain, you can track music usage, facilitate payments to right holders, potentially transforming the efficiency of collective management system. As far as I understand, we are at the beginning of this because the technology is very new, and so I think that when it comes to music industry, that should be the way forward, because these technologies provide platforms which are relatively secure for royalty distribution, tracking use by people of music, and so on and so forth. So I think there's even more investment. So this is a good start, I would say. This initiative by the Association of Copyright Societies. So I have mentioned collective management of copyright. So collective management organization play important roles also in small island economies, where of course individual rights management proves impractical. I am aware of this Eastern Caribbean collective organization for music rights, which shows how regional approaches can achieve economies of scale impossible for individual territories. And I know that there are reciprocal agreements between this collective organization in the Eastern Caribbean and with collective societies from Europe or America, which of course makes sure that the Caribbean society can represent virtually the entire worldwide repertoire of copyright music for its members. So further investment should be made in this field because music is a Caribbean asset, which should be valued as far as possible. And what about innovation in IP valuation and financing in the Caribbean? One of the most significant developments in Caribbean IP asset management is, for example, the Jamaica's pioneering work on IP valuation for collateral purposes. Supported by the Caribbean Development Bank and the Inter-American Development Bank, the GIPO, the Jamaica Intellectual Property Office, has developed frameworks allowing entrepreneurs to use IP assets as collateral for bank loans. That's interesting. It's an initiative which provides IP, until now, has provided IP valuation training to over 400 persons, 65% women, and represent a good approach to IP monetization in developing economies. So this project completed, for example, IP audits for 7 Jamaican business, creating IP profiles and valuations that supported loan applications to commercial banks. So IP used as a tool to get loans, right? Which I find very, very innovative for the region. Of course, another area where Caribbean small islands have a competitive advantage is traditional knowledge, right? As both cultural and potential economic assets. And here I think Caribbean islands could and should do more, learning from experiences in other continents, Africa, Latin America, for example, the Andean group, the group of Andean countries has many decades, 3 decades ago, has implemented an access regime to genetic resources, to TK. And here I think the Caribbean islands are a bit behind, and they should do more to protect their traditional knowledge in agriculture, and especially agriculture and food, by also creating a framework, a platform for the economic exploitation of such TK, of course, in line with the social public interest and the broader interest of the region. And again, here, taking inspirations from other experiences around the world, especially from other global south regions, as I said, Latin America, Africa, some African experience, the Asian subcontinent, the sub-Asian, the Asian continent, the sub-Indian. So, just to conclude on capacity building, of course, the success of IP frameworks in small island states in the Caribbean also depends critically on sustained capacity building and international cooperation. The World Intellectual Property Organization from time to time organizes events, technical assistance, but I think should do more. I'm saying that because I sometimes work for WIPO in technical assistance, traveling to Africa, traveling to Asia, but I never traveled to the Caribbean. I mean, I know there are some initiatives there, but as far as I understand, the focus is on other regions more. I think this is a pity because the Caribbean should attract attention. And WIPO has lots of resources, and therefore organizing more workshops, more events there would be useful, would be helpful for the region. There are already specialized programs such as the Technology and Innovation Support Centers, the Global Entrepreneur Empowerment Program, which has supported women entrepreneurs in Jamaica, St. Lucia, and other. But I think it could do more. So this was my intervention. I spoke for 21 minutes, so I respected the time. So thank you so much.
Thank you so much, Enrico. I think that was a very engaging and information-rich presentation, an excellent start. I am sure that for our audience online, you probably have 1 or 2 questions you would wish to ask. Please drop it in the chat. Hold on to your questions. We are going to take our next presenter, and at the end of all the presentations, we will certainly hope to get around to taking most, if not all, your questions. So I'd like to turn over now to Andrea.
So yeah, I must admit I feel in trouble because I prepared some notes, but then Enrico said everything I wanted to. I'm sorry.
was thinking the same thing.
I should have.
But so let me just take a different route, and with Natalie's permission, I will freewheel maybe for 10 minutes, and then we will have a discussion with Henry. Okay. About being too complete with his presentations. Now, well, one of the points was, of course, what is exactly intellectual property and what it can do for developing realities. I'm not an expert in the Caribbean region, so I will stick to the general theory, And of course, there are plenty of definitions of intellectual property, but my favorite one is that intellectual property is a special form of property on intangible assets, which works by turning non-rival assets into rival assets. And this has been, of course, a problem for developing countries for many reasons. So essentially, what is a non-rival asset? If you have a tangible form of property, let's say this is my mobile phone, this is a bit old, but you can immediately see it. This is my property, and you cannot use it without my permission. But if you think about it, not every asset on Earth works in the same way. For instance, ideas don't work in the same way. The typical example can be music, for instance. We can all listen to the same song, and the fact that we're all listening to the same song doesn't prevent you from doing the same. If I'm driving my car, you cannot take it without my permission, but ideas per se can be freely shared. IP works in this way. You take these assets and you turn them into actual property. So stuff which belongs to an individual, a patent belongs to an inventor, a trademark belongs to a company, etc., etc., or to an undertaking, etc., etc. And this is, of course, problematic in the developing world dynamic, because when it comes to development, I think you can divide the world between two categories: those who have technology and those who want to have access to that technology. And of course, every region and every country on Earth is different. So for instance, the Caribbean, and I think Enrico explained this very well, has its peculiarities. And this is, I think, a second mistake is thinking of the developing world as something which is all the same. They are developing countries. No, every country must find its own pathway to development. And for instance, I did some work for the Andean region. So Peru, Ecuador, etc., etc. They are developing countries, but they have nothing to do with Jamaica or Cuba or other realities. So this is essentially what IP is. And for a number of years, I think that in the international frame, mostly the WTO frame, people said, well, we don't really talk about sustainability, about not just development, but the sustainable development of countries. For instance, the Convention on Biological Diversity was introduced in 1992, and it's one of the daughters of the discussion of the Brundtland Report and the discussion of sustainability. And when the negotiating parties to the TRIPS agreement said, shall we introduce any reference? Shall we do something? Shall we say, understand that IP is not just about commerce, it's also about development and empowering people? The answer was no, we deal only with trade, which is, of course, a legal fiction, makes little sense. And the idea was, WIPO will do the rest of the work. And WIPO has done some work. Recently, finally, we had the Convention on the Protection of Traditional Knowledge, which is relevant to not just the Caribbean, but I think of Central America as well, Costa Rica, etc. So these countries which hold a very important share of biological diversity and the associated traditional knowledge. And so, yeah, I think one of the key things is helping these countries, one, to find their own core strengths, which, of course, when it comes to the Caribbean, it may be, of course, nation branding, it can be branding of their assets, it can be finding pathways to develop their biological diversity, etc., etc. And if you're looking for tips to build a strategy, you can take a look at the WIPO Innovation Index, which clearly shows where innovation is going. And is intellectual property good or evil? That's also a debate which has has evolved. I remember I was little, but in the 1990s, if you read articles published back then, you can see that there was some sort of consensus, even among very distinguished scholars, that IP is something evil created by, back then, three key poles: North America, Europe, and Japan, to do evil things. And of course, if you take a look at the negotiating history of the TRIPS agreement, well, of the WTO agreement as a whole, you immediately see it, because of course, the bargain was agriculture and textile versus intellectual property. So intellectual property didn't really interest the developing world. They were interested mostly in agriculture and textile. And then there was the bargain. Now I think the view has changed, though, because, well, first of all, it's a fact that countries which were not on the IP map 30 years ago now are superpowers. China is, of course, one of them. India is one of them, et cetera, et cetera. So this idea that IP is inherently pro-developed, technologically advanced societies has been a bit debunked. And a second point is that there have been initiatives all over the world. We can talk about Africa, we can talk about the Caribbean or South America or Central America, dealing with IP to an extent or another. For instance, Peru was interested in quality labels because they say we have the best food in South America and we want to use it as an asset. I've never been physically there, unfortunately. Or Kazakhstan has been invested in technological innovation, so they're interested in specific aspects of patenting and business, etc. Tajikistan and other Central Asian countries are interested in their crafts. So everyone should find its own way. The relationship remains extremely difficult. I'll make you an example. At the moment, myself and Professor Graham Duffield in Leeds, we are writing the answer to a call for evidence of the UK Parliament about innovation, food safety, and technology. And that's a very big deal because some colleagues from developing countries have already published papers saying, listen, the AI, robots, this technology is going to widen the divide between countries which own technology and countries which don't have that technology. So far from leading to a more open and democratic world, we can have a new form of unbalance and inequality. In a period where we believe that with the right international cooperation, with the right consultants, with the right mostly public funding, we could have done something. Now, all of a sudden, AI technology is bringing new imbalances. What can be done? Well, I must say there are a number of cooperation agreements between different regions and between different countries. Some countries are more active than others. Is it enough? No, it's not enough. I think we need more. I don't know, a country I know it's pretty active can be Switzerland, for instance. They are financing a number of cooperation missions. And of course, there are international institutions which probably have seen better days, as you said, like WIPO could do more. FAO is doing a lot. The United Nations Food and Agriculture Organizations is doing a lot. Another key point which I would like to make, however, is that a key word in the TRIPS agreement is the concept of technology transfer. Okay, and reading what some colleagues have written and reflecting on it, I can say that maybe, of course, feel free to disagree. I don't really like the concept of technology transfer because it's this very 1990s concept that there is the big country who gives stuff to the small country. And this sometimes has worked, but most of the time hasn't really worked. And I believe that the COVID pandemic has shown us this. And I have welcomed a number of the statements by a number of countries, also like countries from Africa, saying, we don't really want technology transfer. We want cooperation so we can build our know-how because we have the capacity to do this. And so the idea is building domestic resilience, not just relying on technology transfer. Some years ago, there was a public conference where a very famous executive from WIPO said, we can safely say technology transfer hasn't really worked, at least not in the way the TRIPS agreement puts it. So long story short, and I hope I mean, if Natalie wants me to address specific points, I'm happy to. But I believe that intellectual property creates a divide, of course, between countries with technology, so the so-called AP producers, and the countries who want to have access to that technology. And has the process of spreading this know-how, this information, fair? Not really. Some scholars from African universities sometimes put it this way. The whole world, the Western world, has been built by people who started stealing British technology in the 19th century. And all of a sudden, in 1883, there were the first international conventions on IP, where essentially the old big colonial power said that's enough. Because, of course, if counterfeiting and piracy exceed a threshold, innovating is not effective anymore. You're not going to innovate because people are going to steal your efforts. So essentially, a lot of scholars from Africa say, you are asking us to do in 20 years what you have done in 80 years. So the transition has not been entirely fair. Is IP evil, though? No, it's not. It's just about understanding, as Enrico was saying, what you need and how to do it. Now, in my very personal experience, but again, feel free to disagree because every case is different, I have seen that this form of domestic resilience and creation of domestic know-how works best when there is a strong synergy between private stakeholders, but you need some kind of governmental direction in terms of funding, in terms of the government sourcing know-how when needed, et cetera, et cetera. Is innovation over? No, it's not. Of course, every day there are new challenges, which I am afraid very often they create new divides, of course, because, again, there is a difference between those who can access this technology and those who can't access. In my personal view, and it's not also my personal view, I mean, people, distinguished scholars 20 years ago started talking about a kind of federative view of innovation. So where regions must find their own pathway, not relying on external technology transfer, which doesn't work, because you can see it even in very poor and modest contexts. You build a well in an area where people don't know how to make maintenance to that well. 2 months later, the well doesn't exist. So people from Asia, people from Africa have already stated this. We don't want this kind of technology transfer. We want a system of cooperation which helps us to build what they have defined domestic resilience. This is pretty much everything I wanted to say, bypassing all the figures and evidence provided by Enrico.
But following up on what you said, I mean, small islands, I mean, developing countries in general, they are also using IP protection to, give value to their resources. Think of, for example, the duration of copyright in Jamaica is one of the longest in the world, 95 years.
Is that a good thing?
Well, the 1993 Copyright Act in Jamaica, which has strengthened copyright protection in Jamaica, and was lobbied by music producers such as Coxon, who wanted protection for their sound recordings. Of course, as I said before, music is a sector where Jamaica has a competitive advantage, and therefore strengthens IP copyright protection pro domo sua, no? Of course. So, IP, of course, is both used as a sword by developing countries, but of course in sectors where they need technology from other countries, they need to use flexibilities in order to soften IP. It's a kind of variable geometry that they're using. Exactly. But this is what many other countries do, not only developing countries, but also, of course, the European Union is strengthening protection for GIs because it's a sector where they have competitive advantage. the US protecting its pharmaceutical companies with strong patent rights. Of course, each country at the end of the day is pursuing an IP policy which is suited for their own economy, right? And then that's what I think a small island should do, of course, respecting trips, right? I just wanted to follow up on what Andrea said.
We'll come back to Life Plus 95.
Yes.
In the discussion segment. Okay. Well, that leaves me then to introduce Keisha. She is joining us online from Anguilla. Keisha, over to you.
Thank you, Natalie. Can you hear me okay? You can hear me? Okay, great.
Hearing you perfectly.
Wonderful. Thank you. Thank you very much for the invitation to be able to be present today to present to you. I'm sorry that I'm not there in person. I would have much rather be with you, but no, virtual is just as effective, I think. Following the two previous speakers, I think I'm going to have a little bit of a challenge because, as Andrea pointed out, I don't want to be repetitive. Some of the important points were already brought forward. However, I just want to give a little bit of, bring into context my role as it relates to IP in the Caribbean region. I am a private practitioner, as you indicated in the introduction. And oftentimes when I tell people that I'm an attorney practicing law in the Caribbean, focusing on IP, they automatically assume that most of my clients are local brand owners and inventors in the Caribbean region. However, for most of us practicing in the Caribbean, we represent more of the international global brands that are seeking to protect their IP within the Caribbean region. My practice spans over cross borders. I represent brands in over 25 different islands of the Caribbean region, which gives me an opportunity to have a view into the IP regulatory framework within these different jurisdictions, and also have the opportunity to observe the challenges that local brand owners and local inventors have themselves to using the framework that's there for IP protection. I know Enrico mentioned briefly WIPO and the work that it's doing throughout the Caribbean region. And I work as the consultant for WIPO in their project supporting women entrepreneurs in different Caribbean islands. We completed last year the project with St. Vincent, St. Lucia, and Belize. And we're about to start again working with women entrepreneurs in St. Kitts and Nevis and Antigua. And there's one other country, I can't remember which island it is right now because we're just about to start. But in that project, working with WIPO on that project, it gives us a very front row seat in identifying some of the issues that were previously discussed that at a risk of being repetitive, I won't repeat, but some of the challenges that these small businesses, these small enterprises face in protecting the IP and growing the value of the IP. And I'm going to go through that briefly in my presentation, but I was very interested in some of the other points that Enrico raised also. And that one was the JIPO office program to issue valuations on IP assets so that it can be used as collateral for bank loans. That's one of the most important and significant selling points that I use when I'm working with the small enterprises in the Caribbean region. The fact that they are not able to have not identified their intellectual property, and they have not taken the extra step to protect their intellectual property and then to use the intellectual property as an asset for their business and leverage it to the extent that they can for financing, which is always a need for some of these businesses. Another point that he raised was the idea of insufficient political will, which is one of the points that we always experience as practitioners within the region, as members of multiple bars and different bar associations. This always comes up. The practitioners, the brand owners, the inventors want to see the establishment and the growth of intellectual property rights and intellectual property regimes within the region. But then when you present that to the legislative body, then there's just this lack of political will to take those ideas and those concepts forward. Complexity of harmonization is another point that was raised. And as one who practices across borders, it's fascinating to see over 25 different jurisdictions and over 25 different IP offices that have their own systems, procedures, mechanisms, and legislation that if you want to protect your IP in multiple islands within your region, it presents a financial burden. It presents significant complexities. So the idea of harmonization is always welcoming, as to practitioners and to brand owners. And the conversation always comes up, and we're hoping that we can see some movement. You also mentioned a regional IP office. Again, we hope to see some movement there. But we know it's far off, but having the conversation is always helpful and shine some light on some of the challenges that we have within the region. So I did prepare a very formal presentation, but a lot of my points, like I said, was already covered, and I don't want to be repetitive, but I'll run through some of what I wanted to say in my presentation from a practitioner's point of view and from someone that's really in the trenches. I am from Anguilla, which is already the Caribbean is identified as a bunch of small island nations, but Anguilla is one of the smallest of the small. So we, if you want to talk about really small, we are a very, very small nation. But in addition to that, we are still under the British rule. So we have some other challenges from benefiting from some of the agreements that were mentioned earlier, but we also have some benefits in that we still allow some registration under the British system, re-registration in Anguilla, that makes it easier and more cost effective. But I want to focus particularly on how small island Caribbean countries such as Anguilla, St. Kitts Nevis, and Montserrat, and emerging economies like Jamaica, Trinidad, and Barbados can still strategically use IP to compete in a global economy that is shaped primarily by post-colonial structures. For example, when we hear of Swiss watch, Italian leather, we immediately think of quality. In the Caribbean, we want to see us achieve a similar association, and we can get there through strategic IP use. So someone mentioned earlier what they thought, their version of what intellectual property is, but oftentimes it is referred to as creation of the mind, inventions, work of arts, design, symbols, and brand names. And we all know within the Caribbean, there's definitely no shortage of creativity. Patents, trademarks, copyrights, and trade secrets are the four main core categories of IP. And what IP does is it turns intellectual creativity that I just described, that is ever present within the Caribbean region, into an economic asset that we should be able to benefit by owning it, trading it, or licensing it. An example is Bob Marley's music. The catalog remains one of Jamaican's strongest IP assets, generating revenue worldwide for decades. And Sandler's Resort, another very famous Caribbean brand name. But what is the regulatory framework that we have within the Caribbean region that can be used? At a global level, we have WIPO and WTO TRIPS agreements that establish baseline rules. Regionally, we have in the Caribbean jurisdictions coordinating through CARICOM, OECS initiatives that were mentioned earlier to harmonize IP practices. And nationally, we have 25 plus Caribbean jurisdictions where the offices handle filings and enforcement locally. These practices, however, present challenges. The frameworks are often modeled after developed countries and are not tailored to the realities of the challenges within the small island states. This can create barriers for entry into larger markets, and it limits our ability to innovate on an equal footing. For example, patent filing in US or Europe can cost upwards of $20,000, and this is prohibitive for most Caribbean entrepreneurs, just cost prohibitive off the bat. Registration alone, however, does not maximize the IP value for any business or any brand owner, any Caribbean entrepreneur. Strategic management is required. In the program that I mentioned earlier for WIPO, one of the things that we try to teach is how to value the IP, how to license it, how to use it in collaborations and joint ventures to really make the IP work for these businesses. Getting them to understand that basic concept sometimes can be a challenge. Strategies such as licensing local designs in global fashion market housing, exporting brand food products, presents challenges in and of itself for small Caribbean businesses and enterprises. Geographical indications was discussed earlier, and I'm sure that Natalie is going to discuss that in more detail, but I just want to point out how GI connects products to geography, ensuring authenticity and protecting cultural identity. And this is something that we're seeing being used more in the Caribbean. One that comes to mind that I love is the steel pan GI that was established for Trinidad and Tobago. On a larger scale, we have Jamaican Blue Mountain coffee. These protections add prestige to the market value, but it also ensures that local producers within the Caribbean market can benefit. Country names is another one. Country names themselves offer valuable brand assets. Made in Jamaica, Cuban cigar, Bajan rum. These instantly come to mind and they communicate authenticity of origin. They allow the locals within the market to really benefit from the use of the country names. They enhance tourism, support export, and establish a national image. Examples of some islands register their names as trademarks to prevent misuse and to protect its reputation in music, coffee, and athletics. This helps to mitigate the risk of misappropriation by others and allow for locals to really benefit from the use of the country name. Grenada nutmeg, Demerara sugar are two other examples where this is done. And I know that some islands also have specific requirement for consent to use the name as part of a trademark or logo. Now, trademark is one of the more popular versions of IP, categories of IP that's used within the region, and it protects logos, brand names, and distinctive product features. This allows the different businesses to differentiate themselves with loyalty and create long-term brand equity. Some examples within the Caribbean region: Appleton Estate Rum, Red Stripe Beer, and Digicel, which is a regional telecom giant, and the Monget Rum. Without the strong trademark protection, these products could have been copied abroad and diluted. Too many small businesses within our region, however, fail to secure their trademarks internationally, leaving them vulnerable. And one of the major prohibitions for these businesses is cost. IP protection across borders remains difficult and expensive. Going back again to what Enrico mentioned, the movement towards a regional IP office and some kind of harmonization would help in this area. The cost to protect a trademark within the Caribbean region could range anywhere from $400 to $1,500 from island to island. The proximity of the islands are very close, and so the need for cross-border trade is important. In St. Lucia, one of the companies that I worked with was it was a female-owned business that was manufacturing tea. Very tasty, very good quality product. The company had received a lot of support within the island for packaging, boxing, making it very presentable for the shelf. But St. Lucia itself was too small or not large enough of a market to really generate the revenue that this company needed to sustain itself. And so it was necessary to export, and just export to islands that were not very far from that jurisdiction. So the need to protect the IP within the trademark, within the solution market and the neighboring islands was very present and very important for this company. But the cost and the complexity of doing this became a challenge for her and forced her to stay within her solution market and lose on the substantial growth and revenue that her business could benefit from. Counterfeit is another issue that comes up within the region. Parallel imports, and that can damage brand identity and integrity. And so registering the IP and protecting the trademarks within the region becomes very important in order to allow for the original brand to be preserved. IP can be used as a tool, a significant tool for Caribbean countries as it relates to exporting raw material. When this is not done, developed countries profit from the branding and the value-added protection. I think there was a mention earlier by Andrea, if I'm not mistaken, where it was stated that there was a convention by WIPO for protecting traditional knowledge. I recently co-authored an article with a colleague, and we were talking about cannabis and how the ever-growing cannabis market and how the Caribbean is strategically located for many factors, the weather, the growth of cannabis within that market, and the traditional knowledge of the different strains of the product. And the ability to protect this knowledge and the ability to secure this knowledge within the region will be very significant to the growth of the cannabis industry within the Caribbean region. By leveraging IP, small Caribbean countries can move up the value chain. Instead of exporting raw cocoa, Grenada could market branded Grenadian chocolate, for example, as a luxury product for IP protection, for GI protection. So I think I've covered most of what I wanted to cover within this section here. I wanted to just kind of mention that I do agree with Enrico that movement towards regional IP office would benefit significantly the Caribbean countries and Caribbean brand owners. And some level of harmonization would definitely add some benefits also. Thank you.
Thank you so much, Keisha, for that presentation. I think you definitely gave us a very practical insight into some of the things we introduced, I suppose, theoretically, and we're hearing you echo very much some of the key points that we've observed from a research standpoint playing out in real life from a practitioner's perspective. So I really wanted to thank you for that, and especially Keisha, what time is it in Anguilla? Oh my goodness, thank you so much for, you know, you look like you're 10 o'clock, but somehow I think it's like 3 a.m. And this is just wonderful.
Thank you.
All right, so I'm not sure if we have any questions. Can we open up for questions? We're checking our chat. If you have any questions, you can certainly drop it in the chat. So while you give that some thought, or while our audience is giving that some thought, I will just do a quick recap of our first session. We heard from Enrico, and I wanted to just highlight some of the points that he made, and of course, add my two-bit rebuttal. So it's interesting because you mentioned old colonial legislation and how that has shaped the current status of IP law in the Caribbean. And Jamaica for many, many years had the 1857 UK Patent Act, which was only replaced in 2020 and didn't become effective until some time after that, because we first had to ratify the Patent Cooperation Treaty. And I want to put it to you that the 1857 Act was perhaps a better act for Jamaica because of our level of development and all the challenges Chisha highlighted about the difficulty of financing the registration of a patent. In fact, also what Andrea has highlighted, Jamaica is a user of technology and not so much a producer of technology. So the idea that novelty was national under the 1857 Patent Act was actually beneficial for a small island state like Jamaica, where the innovation was not happening locally so much so that it was that we were being asked to respect the innovation of others. And this is a common recurring theme where the basic legal framework is being activated, and I want to say almost weaponized, to enforce enforcement rather than being a real leapfrog for local countries to be able to push their own local IP to jumpstart their businesses. So for a long time through the trade agreements, it has been putting pressure and putting you on watch lists if you were not complying. So the IP framework can very much be a shield and a sword. You also spoke about the 4 WIPO studies, and it's interesting you mentioned copyright as a big champion. The 4 WIPO studies were done on the contribution of copyright industries to the countries, the one on St. Lucia, Grenada, Trinidad, and of course Jamaica. There was an updated study for Jamaica conducted by Vaness James. Vaness James and his team did all 4. But we've never done a similar study on the contribution of industrial property to the country. So when you say that WIPO could do more, this is immediately what comes to mind for me, because it really has been limited to contribution of copyright industries. Enrico, you also spoke about this regional IP office, and I want to say that there is a test case, CAROSA. CAROSA is a Caribbean regional organization for reprographic rights, which was recently established. So we have a number of reprographic rights organizations across the Caribbean region. So in Jamaica, we've got Jam Copy. In Barbados, we have B Copy. In Trinidad, we have TTRO and so on. And the whole idea was of coalescing the effort, economies of scale. Can we have a CAROSA for the entire region? CAROSA has recently become a reality. The test case being they're trying to sign their first license with the University of the West Indies, because the University of the West Indies, as you know, is located across the region in several different islands. But again, the deal that you can strike with Jamaica, which has had a long-standing licensing arrangement with Jam Copy, wouldn't be the same for the others, where B Copy had a different arrangement for the same University of West Indies in Barbados, but a different arrangement from the one at Mona. And then come down to Trinidad, which is kind of on the lower end, where Trinidad was not so necessarily eager to enter a license arrangement. So how can one regional block of rights holders then negotiate with another regional block of wanting to use that catalog? So we do actually have a test case. I don't know if later in panel 2, when Diane Daly comes on, she's very much lead on CAROSA. She might want to jump in on that. You also spoke about signing of treaties, TRIPS obligations, and so on. One of the things that we observe is that there are many countries in the Caribbean region that are actually not signatory to some of the key treaties that would pose an impediment to their ability to use IP to innovate. So St. Lucia is not a member of Beijing, Grenada is not a member of Beijing, WCT, WPPT, and so on, and I could reproduce the examples. So when you mention the ECCO, the collective rights management for music, but if you're not a member of Beijing, then you're at a disadvantage, right? So there is, again, Keisha hearkened to it, you need to have a champion, and you need to have the champion from the public sector and the champion from the private sector. You also mentioned, Enrico, the challenge of being, I can't read that, the expensive cost of travel between countries. This is a crucial problem. Keisha, I'm so glad you mentioned that about the distance between islands. It costs less money to fly to London from Kingston than it does to fly to Anguilla. And to get to the BVI, I have to overnight somewhere. I can't get there directly. For most countries, you have to fly through Miami, right? So the distance between the islands, although physically, geographically so close, you can just imagine how even more complicated and expensive it is to transfer goods and services, right? So that is a serious drawback for any business on every level. It's not like Europe, where you could jump on a train and be in another country within a matter of hours. You also mentioned about ECHO, again, the pragmatic, I mentioned that one already, the challenge with execution on the ground. Keisha, when I was in Anguilla recently, I heard from a number of persons that although you do have certain copyright licensing organizations or RROs, getting people on the ground to understand what intellectual property is, why they should buy into it, why they should have licenses, that's a problem. So public education at the very base remains a significant problem, not just for the IP creators, but also for the IP users. You also mentioned this, the asset creation, the valuation of the asset. Keisha, you spoke to it as well. There is actually a Security Interest in Personal Property Act in Jamaica. And so that legislative framework that exists in Jamaica could well be a model for other countries in the Caribbean region to emulate. And so I support also what you have said, Keisha. The protection of traditional knowledge. I want to say Jamaica again at the forefront of this, because our recently amended Trademarks Act and our Patent Act has in fact entrenched that any trademark that incorporates the use of any iconography of Rastafari, Maroons, or traditional holders, you will need to show that you have had some authorization to be able to use that iconography, and the Patent and Designs Act quite similarly. So Jamaica has been very much proactive in taking steps to protect traditional knowledge folklore holders in this way. You also mentioned the WIPO in Business project. So I'm glad, Keisha, you were able to testify that WIPO is actually rolling this out across the Caribbean. And I think they are now in their second or third iteration of that project. But I want to endorse what Enrico has said and what you have said, Keisha. We certainly need more, and we need initiatives that are broader reaching, not to in any way sort of diminish the impact of the current project. I moved to Andrea. I was so fascinated, Andrea, when you spoke about innovation users versus innovation creators. And I think your point cannot be overstated, that each Caribbean country has to identify its own core strengths and to figure out really how to balance those trade goals with the intellectual property constraints and opportunities as they present themselves. There is a huge rush across the Caribbean right now in relation to artificial intelligence and how this will impact Caribbean economies. And I think it's very interesting that in your current work, you're looking at how this is creating new imbalances between countries, those who have it, those who don't have access to this technology. And of course, the concept of technology transfer as opposed to state cooperation. And I think these are absolutely very important points that we'll have to weigh in the balance. it's interesting that in talking about AI, Keisha, I thought I was sure you were going to mention this, but the forward thinking of the government of Anguilla, they are the domain holders of AI.com. And this is the most brilliant way of IP innovation at work, because Keisha, you can jump in and tell us how the government has been managing the domain AI.com, and perhaps any sort of pushback or I don't know, certainly juicy invitations to sell it over, right?
Yeah.
And so, yeah, jump in, Keisha, please.
No, definitely. .ai is the domain name owned by Anguilla, and we were it's just a matter of luck, because AI is our country code. And so it has just definitely been a significant revenue generator for the country, which has given us recently some tax breaks. And also we're using it in intellectual property, and we're now setting up a company, and instead of .ltd, we can now set up a company .ai, which is just phenomenal. So we're definitely using it to generate revenue. We're building a new airport, and it's my understanding that they're using the .ai money to do that. We're hoping to build new schools and new roads. And so for us, it's a blessing. We're definitely marketing and taking advantage of what it can generate for the island. So yes, I always speak about it, but I don't know why it slipped me this time. But thank you for mentioning that, Natalie.
It reminds me when Tuvalu, it used to have, like 25 years ago, TV, right? So many TV companies, they try to relocate in Tuvalu, which is an island in the Polynesia, or
I'm thinking of which Italian city could use AI as a text. No, unfortunately, no. TV, yes. AI, no. Well, maybe France, some French city, but Italy, no city with AI. No.
This is just a brilliant example to conclude our first panel on. We're going to take a short coffee break, and we will be back with you precisely at 11 a.m. When we return, we will hear from our other two panelists, Diane Daly and Grace Lindo, and I will pick up the conversation that you started on country names when I also share in the next panel. Thank you so much, and please come back at 11. Thank you.